Good morning, everyone. My name is John Feldman. I'm a partner here at Goodmans and co-chair of our Shareholder Activism and Governance group. It's my pleasure to welcome you this morning to our program entitled Successfully Dealing with Shareholder Engagement and Activism. As everyone in this room knows, activism is growing. Everyone talks about Canada being a shareholder-friendly environment. And as activist funds continue to grow, they are looking more and more at Canada as a place to deploy their capital and engage in activist mandates. Most of what we see in the activist space is quiet and happens behind the scenes, and many people in this room are probably working on multiple engagements right now that nobody else in this room will ever hear, because really the majority of it does happen behind the scenes. Every once in a while, it does get loud, and what we're going to do today is take you through a scenario where that is what has happened. What's interesting in Canada is, let's say compared to the US, in the US, there are institutions that take philosophical positions, whether it's Wachtell Lipton on the legal side or Morgan Stanley on the investment bank side. They will take the view that they can only represent corporate clients. And anything contrary to that is the devil. On the other side of that are those that represent only activists, whether it's Houlihan Lokey on the investment banking side or Olshan Walensky. They will only pretty much represent activists. In Canada, given the volume that we have is significantly smaller than in the US, most advisors work on both sides at different times. And it's always interesting because what it does is it gives people the perspective of each side when working on the other side. So it's a unique arrangement or situation that exists in Canada that I think is just beneficial as we deal with activist situations. The scenario we're going to talk about today is going to be from the perspective of the board, but it really applies from both directions, but so just wanted to give you that context. Just a quick administrative matter for those lawyers in the room, which is that this morning's session will count towards substantive hours of the Law Society CPD requirement. Everyone here in the room and those joining us by webinar will be receiving a proof of attendance email after the session. Please retain a copy of this email for audit purposes. The email will also walk you through how to report the session on the Law Society portal. If you've not signed our attendance sheet at the registration table, please ensure that you do so before leaving so we can get this email to you. With the administrative out of the way, I'd like to quickly introduce our panel. I'll keep this brief since we have a lot to cover today, and you can read more about them on the links in our email. Joel Shaffer, who's to my immediate right, is a partner in Longview's Toronto office and brings deep experience in communications and campaign strategy. He has particular expertise advising boards and other stakeholders in bet-the-company corporate and financial communications engagements, including the conduct of proxy contests, hostile takeover bids, restructurings, and other crisis or special situations. And there is no one better to be in the trenches with than Joel. Usually he will say, I'm going to say whatever I want, and then you try to stop me, or at least so I don't get in trouble. But Joel is outstanding in this area, and we're very happy to have him here on this panel. Beside Joel is Brenda Gosselin, my brilliant corporate partner, who's an experienced and transactional lawyer who advises in all areas of corporate and securities law, including corporate governance, corporate finance, M&A, corporate restructurings, as well as shareholder rights and activisms. And David Conklin, who many of you know, very well, is the co-chair of our Shareholder Activism and Governance group, and is a unique talent in our space. David is a commercial litigator handling a wide variety of business law matters, including those relating to corporate governance, securities, litigation, shareholder activism, partnership disputes, and business valuations. He really does it all. But we're going to focus on his shareholder activism expertise today. We have mics, so if people have questions, feel free to ask us anytime. We'll have time at the end for questions, but if you want to step up at any time, please feel free. There's many people on the web today, so if you do have questions, we just ask that you use a mic, and that way everybody who's online can hear as well. So with that in mind, why don't we get started? Because like I said, we do have a lot to cover. And we'll get started right now in our scenario. But before we do that, I just want to take one quick step back and talk about the fact that 10 years ago, shareholder engagement that everybody talks about now wasn't really a thing. Even though we hear a lot about it these days, it's not really clear what it means and how to do it. So Brenda, can you explain briefly what shareholder engagement is and why it's important, and whether this is a board or a management responsibility or both?
Sure. Good morning, everybody. I think, as John mentioned, about 10 years or so, there was less of shareholder engagement as a process. And the instinct when run up against a hostile activist was to take a defensive, reactionary response. I think over the course of the last number of years, we've moved towards sort of this engagement narrative where boards are taking a much more sort of constructive dialogue approach. And that's really what shareholder engagement is about. It's about talking to your investors, understanding who they are, figuring out what makes them drive, what makes them tick, what their issues are, and having an ongoing conversation and bettering the company sort of from the view of all. It is an obligation of both the board and management. Everybody's involved in that. The board needs to be aware and of mind as to what's going on and where its gaps are. Management is often the closest to first information about who's buying in the company, murmurings of things of people that are unhappy, not happy, and there has to be a lot of ongoing communication between the two as well. So that's sort of the framework for where we're at today and what will set sort of the framework for this example that we'll walk through in a few minutes as well.
So Joel, have you seen shareholder engagement practices evolve over the past few years? And what does an engagement program typically look like? And do you have any recommendations for best practices?
Sure. Well, first of all, thanks for having me here. After that introduction, it can only go downhill.
Don't let us down, Joel.
From here, so but we'll do this anyways.
All right.
Brenda actually touched on a lot of this. It has evolved. Shareholder engagement, to the extent that there was a regimented program 10 years ago, was often assigned to somebody in the company, and they would occasionally speak to shareholders. Now it is multifaceted with company officials at every level owning various relationships, either formally or informally, and going out. Sometimes directors are going out on their own to ask, not only how are we doing, but how do you think management is doing? And that can be a difficult conversation to have, obviously for management, but also if management is in the room. If you don't have a regimented shareholder engagement program, you really are leaving yourself vulnerable to an activist. And if an activist surfaces, to be reaching out to people for the first time who are your shareholders who you don't actually know, it's not a good look, and you're already, at best, it's not a good look, and at worst, you have a bigger hill to climb. So shareholder engagement, it is regimented. It is the entire annual calendar ahead of time, planned out, and people doing this work across the company, and as Brenda said, sharing communication with each other in real time. And it's not a core competency of the company necessarily, but it is a critical activity.
Thanks, Joel. So David, how does effective shareholder engagement reduce the risk of being targeted by an activist? And should a company change its shareholder engagement practices if an activist shareholder emerges on the scene?
Well, I guess I think about it this way. What is it that causes shareholders to become activists or motivated in challenging a board? It has to do usually with the fact that shareholders expect returns, and there's a difference between their expectations and management performance. There's a second scenario that can lead to activisms arising, which is an activist who looks at a company, or an investor who looks at a company and sees its performance, thinks it's underperforming, and sees there's an opportunity for unlocking value by buying into the company and trying to effect change. In either scenario, I think what the board and management team have to pay attention to is recognizing that they are ultimately responsible for performance and setting the expectations of investors and potential investors. So when you talk about shareholder engagement and what's effective, I think the necessity of shareholder engagement is just dealing with the reality that public companies are accountable to their investors, and they have an obligation and an interest in trying to ensure that they set the expectations of shareholders appropriately and that they execute a strategic plan that can deliver returns consistent with the expectations they set. To the extent that there's a divergence between that, an effective management team and board will be ahead of criticism from shareholders and helping to reshape shareholder expectations by properly setting in place a strategy for trying to achieve the goals that can reasonably be achieved and trying to ensure that shareholders aren't looking at them and thinking that they're failing, or that others who are not invested in the company aren't looking at the company and thinking it presents an opportunity for unlocking value through changing strategic leadership.
I'm just going to say to everybody in the room that we've just saved you guys thousands of dollars and tons of hours. And the reason for that is I've been going to a whole bunch of these activist conferences here and in the US, and for about 8 hours, all that's ever talked about is shareholder engagement. It actually gets tiring. I get tired of hearing about it because that seems to be the conclusion. We should engage, we should engage, we should engage, we should engage. And there's never really anything beyond that that gets talked about at these conferences. So you're welcome. But what I would say is this. Shareholder engagement does help reduce the risk of an activist coming. But if it does come, which is what we're going to be focusing on momentarily, just wanted to ask Joel, what are some of the things that activists do look for when they're selecting a target?
Well, David just talked, touched on this a bit. They're looking for, they have a thesis where they can create value for themselves, and they don't believe that the company is currently executing that thesis, and they want it to. It's that simple.
Yep.
It's not necessarily personal, although some people make it personal. It's about creating value. Investors, a lot of them have to answer to their own, the investors have investors, they need returns. And if they're very smart, a lot of them, we're well past the days of the crazy, person standing up and yelling at a meeting. They have analysts, they're looking at the numbers, they're deep into the sectors that they're invested into. They have a thesis and they want the company to execute it. And what they're looking for is a gap between what the company is purporting to do and the reality. And once they have that gap, they'll also look for like-minded shareholders who are potentially frustrated. And then there are other signals that can help them make that argument. They'll often couch, an activist campaign will be couched in governance. I'm cynical. I don't know how much certain investors really care about the governance. I think they use it as a tool to build a narrative around, another thing to hammer the board with to get their way. But they'll look for governance gaps. They'll look for directors who have been on the board for a long time and don't own very much of the company. So they're looking for that misalignment in interest, and then a variety of other things. There's a long list.
Thank you. I think I'm just going to move now to our scenario, just get right to dealing with activists. So, all right, so we're here. Okay, so let's get into the scenario and start with that. So you give all this great advice of how to engage with activists and acting proactively, shareholder engagement, this, that, the other, and one of your clients is targeted by an activist. You're sitting in your office one day and the general counsel calls. The client has just been contacted by a well-known activist fund who indicated they have recently bought a 5% interest in the company and would like to meet with the CEO. Joel, to you. Do you think that they should take this meeting, and why or why not?
Well, they should take the meeting, but they should know who they need to do their work. They need to know who they're speaking to, what they typically do, what they look for. In addition to calling us, they should be calling their legal counsel as well, and they should be prepared. You should go to the meeting open-minded to the extent, this is a large shareholder, regardless of, you may make assumptions that you see the world differently than they do, but they are a shareholder in your company, and you should go speak to them and hear them out. You should also start planning for what happens if things go sideways.
Thanks. And Brenda, do you agree? Assuming they do take the meeting, what advice would you give them in terms of how to handle the meeting?
Yeah, I would agree with what Joel had said. I think it's important to understand who you're meeting with, do your background research. What are the trends with this particular investor, with companies like yours? Do they take, a more collaborative approach? Do they launch right into battles? Understand, more about them than perhaps they may know about you in that instance. When you're at the meeting, really listen, an active and listening exercise, and really approach the meeting with in earnest. Don't just pay lip service, respect them. They are a significant investor. They may have really good ideas that perhaps you've thought of, the company might be working on, perhaps you hadn't thought of them. Engage them. That will only serve to better the relationship going forward, and also put you in a better position should this end up going sour. That would be sort of my high level approach.
Anything else, David, that they should be doing?
I recognize that one of the challenges in dealing with a meeting like that is you're constrained by what you can say. You can't just have an open dialogue where you're now providing information to a significant institutional shareholder that you haven't disclosed to the market if it's material. And the distinction between what's material and what's not material isn't always so clear for people. And no doubt a management team that can feel like it's being attacked or criticized becomes defensive and will be inclined to say something. And so they won't feel as at liberty to speak as they maybe would like. And I think that makes the dialogue difficult because a shareholder comes to meet you and is expecting you to provide answers to questions. They're not just there thinking that they just want to speak at you. They want you to engage with them. But that's not a simple dialogue to have. And yet not having it presents its own problems. So I think that it's a necessary discussion to have. It's one that probably would be worthwhile role-playing before one actually has it, in the same way that an effective board and management team should role-play before an earnings call, because you suffer from the same kinds of constraints as you would on an earnings call.
Fair enough.
I just would say one other thing, John.
Yep.
When we're talking about shareholders like this, I think it is important to recognize that we're really talking about institutional shareholders. We're not talking about retail shareholders. And for a board and management team, knowing your shareholder base is critical, and recognizing that retail shareholders really do care about day-to-day returns, quarter-to-quarter returns, but they'd have a collective action problem. They can't come together and meet and make effective change or have a representative speaking for them to the board or management team. The people who do act are the institutions who have larger positions and are more sophisticated. And the reality is that as one gets into conflicts, dealing with institutional shareholders becomes more critical, because they're the ones who really end up shaping what happens at a vote, because of the fact that both for the company and for the institutional shareholder, getting to retail shareholders, motivating them to vote and express a view is a challenge.
Yep, absolutely, absolutely. And you had a question?
So
Did you want to just?
we
The
can-
question was, I'll just repeat it. The question was whether, David, it's normal to record or take notes in a meeting like that.
If you're recording a meeting, you'd probably want to, I would tell you, you'd want to tell everybody you're recording a meeting, but I would also encourage no one to record a meeting.
that's probably not a good way to start a relationship.
The moment you're recording a meeting, the dialogue totally changes. Everyone becomes anxious around the fact that there's somebody that's taping it by audio, or, if God forbid, videotaping a meeting with a shareholder. But taking notes, I think, is important. And it doesn't mean that everybody in the room with a management team takes notes. But having somebody who is consciously taking note of questions that are being asked, issues that are being discussed, and what the company is saying and what someone else is saying is important to allowing them after the meeting to then preparing, I would suggest, an important memo that does review what was discussed, and then being able to act on that. But then eliminating or reducing the opportunity for conflict around what was said. And I guess I would add to that taking this one meeting is the beginning of a dialogue. Because if you have a meeting with a fund or an institution and they come with their concerns or their questions, you'd be short-sighted to think that they will never ask questions again, or they don't expect to see how you respond. And so it is a relationship that either develops successfully or fragments and becomes the source of opportunity for me and Joel to do work. And John, because it becomes conflict-based.
Ignoring them is not going to make them go away.
I would just say also that, one thing that we find is often the case is when the investors are coming in, the Holy Grail is to make sure that they're not restricted. So when they come into this meeting, they want to make sure that nothing is said to them that's going to put them in a position where they can't trade. So that's sort of the other side of the equation, and that's something that's very important from their perspective. Let's move on to our next slide in our little story. The client meets with the investor, and it seems to go reasonably well because David advised him to behave nicely. The investor asks a few pointed questions about recent performance and the company's capital allocation strategy, but mainly just listens to what the CEO has to say. Nothing else happens for a few months, and then seemingly out of nowhere, the company receives a 10-page letter from the activist that outlines a litany of detailed complaints about the company's recent performance, its corporate governance practices, and its current strategy. The letter suggests that the company must immediately consider strategic alternatives to enhance shareholder value, including selling one of its key assets and distributing the proceeds to shareholders by way of a special dividend, and indicates that if the board does not do so, it is prepared to take all necessary steps to protect the interests of all shareholders. By the way, we have this precedent in our files, if anybody. They conclude by asking for a meeting with the client's board of directors. David, what does the company do now? Does the company have any obligation to publicly disclose its receipt of the letter? What would you tell the general counsel if he or she asked you whether the company should impose a trading blackout, for example?
I don't think the company has an obligation to disclose the receipt of a letter. The letter itself isn't anything more than somebody else expressing a view on the strategy that the business should follow. In terms of a blackout, from what you've laid out, there's no material non-public information that comes from the fact that somebody has a different view of the strategy. But what should the board do and what should the management team do? First, from the management side, if the letter comes to just the management side, it's not a letter for management to keep them to themselves. I think it is a letter that they should share with the chair of the board and with the board as a whole. I think beyond that, it's important to recognize that management has an interest in strategy. They're the ones that have worked on the strategy with the board, sought the board's approval of it, and are executing it. They now are receiving an outside person's critical view, which means they do have a conflicted interest. And I think to try and ensure that the company's best interests are protected and even the management team's interests are protected, I would look to the board, even in a small company, to set up a committee of independent directors. They don't need a financial advisor unless they've got the resources to hire one, but to properly evaluate the strategic alternatives that are available to the company and that somebody is presenting, and to ask the question, have they missed something? And to satisfy themselves that they have the right strategic course going forward. I don't think they need to necessarily do more with the letter, than respond to the letter, acknowledge they received it, and tell them that the issues are being addressed. Now, because the meeting is asked for, I think that you could, going back to where we started, offer them a meeting, but that has to be, going back to where we started as well, a carefully scripted meeting that I would want to have as part of the review that a board was considering. So I'd have the board first meet, committee appointed, evaluate the strategy, meet with the investor, talk to them about their views. Don't necessarily come and say, we've thought about it and here's what we think. Take in what they say and then reevaluate it and come to a conclusion about what you think is best.
Okay, well, how about, but Joel, but what, are there any situations where...
John, we got a question
we have a question? Yes. Do you want to pass the mic? Thank you.
Just wondering if your comments, and particularly your response to your earlier comments about what the appropriate conduct is of the management team in the context of a discussion with the activism. They have to be very careful of what they say, to not share material, non-public information, and so, yes, they should have a meeting, but it's a difficult meeting. Whether that response would be different if the shareholder itself was engaging less hostile, and most importantly, prepared to be restricted from trading as long as they were privy to confidential non-public information, would you then consider the company be more forthcoming in that regard?
I'd say it's something they could consider, but I would be apprehensive, just by virtue of the fact that if I start sharing material non-public information with somebody that is outside the company, even with their undertaking that they will acknowledge that they're in a restricted form going forward and they won't be buying or selling in shares, my concern would be that now I've put them inside the company and I'm almost making them insiders for an ongoing discussion. And I don't know that that's an appropriate place for shareholders to be. I also would have a concern about being confident that the information you share with the shareholder is going to remain confidential within that shareholder group and won't become information that somebody inadvertently or advertently passes on to someone else that the company doesn't have a relationship with. The OSC over the past couple of years has really focused on cases involving insider trading and tipping where the information isn't being passed from the issuer directly to the person who is the target of tipping or trading. It's 3 or 4 positions removed from the company. So I would be just apprehensive in terms of asking the company, why do you feel that it will be positive to share this information with the investor? And it would only be in I think, a very rare circumstance that I would feel comfortable sharing that kind of information with somebody outside the institution, outside the company.
Another
Good with
question.
you?
That's just my
Sir,
view.
we have another question. Behind you. Yes. Yes, sir.
Microphone. David, I wanted you to spend a little bit more time. I've heard Longview talk about the importance of having all of your advisors lined up beforehand, and you've just said to wait to hire a financial advisor. Since this debate is usually over valuation, why would that not be the first other advisor you'd have in the room?
All right, so I don't want to say wait. That's something I can be clear on. Many public companies that become the focus of criticism like this really don't have the resources to think about immediately hiring a financial advisor. There are some public companies that are smaller junior mining companies, for example, or other startup companies that are going to say that hiring a financial advisor is something that they don't think that they should or have to do. And I'm saying that if you are in that position where you don't have a financial advisor or you don't want to engage one because of a concern for costs or thinking it's just not necessary, that doesn't mean you do nothing. Now, if you're a more mature public company, you may already have an advisor, in which case you should engage them in that discussion. And you should ask yourself, has your advisor, if this has been your advisor for a period of time, missed something? And what is the answer to this criticism that's coming to the company? And if you don't have one, then engaging one, I think, would be appropriate.
And I think what David was talking, because David and I actually had this conversation, I think because a lot of this lives in the TSXV, not necessarily at the sort of the larger companies, just from on a cost-benefit analysis, sometimes boards may say we're not going to do it. But in an ideal world, a board is getting advised in every aspect of that financial, proxy advisory, PR, legal. I mean, that's the ideal scenario, as long as it makes sense to do it.
Well, what I would add to bring it back to the case a little bit, you've now received this letter, so you've gotten the sort of the legal and the strategic response, which I completely agree with. There's 2 things you've got to be thinking about from a comms perspective. One is you're now papering the file, is what my friends here would say, right? Yep. Everything that's going back and forth, there's a really good chance at some point it's going to be part of the public record. So be very careful on how you respond. The other thing you have to be prepared for is you may not control the timing of when it goes public. If an activist is sending letters into you, they may choose to leak that to Bloomberg at some point, for example. That seems to be where these things often end up lately. Yeah. There's a very aggressive reporter there who's good at getting them. Or they may issue a press release and say, here's what we've said to the company. So you also have to be ready to respond, which I suspect was your
Yeah.
that you
No,
know.
John,
And
I
just,
wanna go
sorry,
back to
just
the-
one the other thing to keep in mind, just on Joel's point, is this background, and from a governance perspective and a board sort of obligation and duties perspective, all of this process, and we talk often from a governance perspective and a fiduciary duty perspective about process. If it goes to a full-blown proxy battle and it comes time for the issuer to be filing its own circular, all of this is going to framework and form part of the circular in sort of the background. You don't want to have an issuer just saying at the end of the day, oh, we didn't really do anything, we didn't look at this properly. So you have to keep in mind sort of at the outset that all of these things are going to set the stage for your position at the end of the day vis-a-vis what you're pitching to shareholders as well.
We always wonder that if we draft a really great background section, whether there's actually anybody that's reading it. You'll let us know. We do this and then we wonder, but
I read it.
Joel reads it, but that's really it.
John, I
yes.
don't want to miss this because the question was, how would I respond to a company that was in a position where it was considering sharing MMPI with an institutional investor?
Yep.
I actually think it would be a very rare occasion as well that I could imagine that an institutional investor would be prepared to have a meeting and receive MMPI. Most investors are interested in seeing returns and seeing strategic initiatives introduced they think will achieve results, but they don't want to be restricted. Because the problem is if the company shares MMPI with them, when are they unrestricted?
No, but I would ask, it's Jeff, right? I would ask Jeff, is there a circumstance in your world where it's something that's beneficial for you to have that information as an investor?
Sure. I mean, if you're, firstly, you have to be a longer term committed, really aligned, not somebody who's, you said they have one agenda they're presenting, but they really have another agenda. Right. They don't really care about governance. So you have to have a more aligned longer term objective. But I mean, I asked my earlier question and it was in the context of a situation where before I engaged with the board, I was already restricted because I was approached by an activist investor who was having little success with a corporate target. So I chose to be restricted by them. And so when I called up board members, I said, you could feel free, not that you should or you will or you must, to engage with me because I am restricted. So this is their view. This is our view. Can we speak openly? So there are circumstances we have certainly chosen to be restricted in that context.
Yeah, and I have clients that as well in certain live situations have chosen to be restricted and have had set up confidentiality arrangements where information is being shared. And it's not always with the company. There's this crazy new rule in our insider trading regime that talks about if you're also in a special relationship with the company if you are considering, whatever the hell that means, evaluating or proposing a takeover bid or an acquisition. And so I've spoken with Nizam about this. I don't know if he's here, but I've spoken with Nizam about this and saying, what does consider mean? He said, look in the dictionary. So somebody's thinking about buying a company. You're a significant shareholder. They tell you about this. You're restricted. You're potentially restricted. And I'm seeing this situation. And to David's point, how do you get out of that? It's a tricky situation. In this particular instance, they want to be restricted because they're working with the acquirer. But had they not been, if they say at some point we want to be restricted, how do we do it? And we're talking that through because it's a tricky situation. So, what's that? As an offeror, you can buy a toehold, but if you're not a joint actor, then you're sort of floating on your own. But in their particular instance, they chose you can as an offeror, you can buy a toehold. They may not necessarily. You're not if you have material non-public information. So that's the tricky part.
By the way, just to give you my partner who was formerly a leading research analyst, was actually in a situation with a major corporate client, and the corporate client chose to provide him with information just so he couldn't restricted him involuntarily.
We were recently
happens.
in that situation. If you've happened to read about the Detour Gold Paulson matter, that was one of the issues that we dealt with. Just for the interest of time, I'm going to move on to the next part of our story. And here, what happens is the board meets with the activists, and although the activist has done a lot of research and understands the company quite well, the board is not convinced that there's any real merit to its ideas, and believes that the company would be best served by continuing to execute on its current plan, and tells the activist as much. About a week later, the activist delivers a second letter to the board. This one is more aggressive than the first, includes personal attacks on the qualifications and track record of a number of the directors, and is accompanied by a requisition for the company to hold a shareholder meeting immediately for the purposes of replacing the entire board with a slate of directors to be named at a later date, as well as considering a resolution directing the company to sell the asset. At the same time, the activist issues a press release disclosing the requisition and attaching a copy of its letter to the board. So Joel, how important is it for the company to publicly respond or to attempt to rebut the activist arguments?
So two-part answer. Part one, it's critically important for the company to respond. I think the lawyers would agree you have a material event here, so you should be talking about it, or something that a potential board change, so you have to respond. Technically, you have 21 days to respond to a requisition and decide if all the I's are dotted and the T's are crossed, and then you have to set a meeting date if it is a proper requisition. If you don't set a meeting date, then the activist can set a meeting date. So you're definitely going to respond. Now, the second part of the answer is the nature of the response. You may feel that you are in a fight. The conflict is certainly escalating, but you're not at a point where you're making fulsome arguments. Nobody is voting yet. That's potentially months away. So no, you're not going to go point by point and dissect the activist thesis at this point. What you are going to do, ideally, is respond confidently, calmly, and re-articulate briefly your strategic view of the world, why what you're doing is working. And you'll get into the deeper dive later. But when somebody says we want to change the board of a company, yes, the company should respond.
Okay. And Brenda, are there any sort of, Joel just touched on it, but any legal considerations that you would sort of think about in that context?
I guess two points to make. One, if it's, and Joel mentioned, if it's a proper requisition, and we'll get to that in a minute. If it is a proper, valid requisition, then the company does have a legal obligation to call a meeting within 21 days. There's no, other than in BC where it has to happen within 4 months, there's no real regulation or rule about the timing for which that date of the meeting has to happen. So that's sort of the first point of strategic thought in terms of, and I think I'll let David speak to sort of the benefits and cons of having it sooner rather than having it later, and the timing that you want to maybe call it. If it's not or what you think there are gaps in the requisition, even technical gaps, this is often used as a tactical approach by the company to sort of test the resolve of the other side. It's the first sort of point in time where you can say, okay, do we make a challenge here? Do we say this isn't valid? What will the response be? Will they just come back and say, okay, we'll resubmit? Or will there be a fight? Will it end up in court? It may give you insight into the kind of player that you're dealing with at the time, and it's sort of a first early look at whether or not that makes strategic sense at the time.
Yep, that's great. And sorry, go ahead, Joel. You were saying?
Just I would add to that, some companies find a reason to reject a requisition. You have legal grounds to do so. This I was not in the proper place. You didn't do this. Let's say legally you can do it. From a comms perspective, how does that look to the world? Right? You have a shareholder who's requisitioned a meeting. They have their 5% cobbled together or more. And this company is saying, well, technically you didn't get it right. So remember, you're building a narrative here. So you can reject it, but think long and hard about how that's going to look in the court of public opinion.
Well, Joel, that point really gets to, I would say, the standard strategic response of boards that receive requisitions. And it has been to try and delay a meeting and frustrate the shareholder that's requisitioned the meeting as much as possible. And the reality of that strategy is it's escalation based. My perspective is that by the time a shareholder's acquired 5%, hired counsel, worked with an advisor, put together a letter and decided that they're going to requisition a meeting, they've reached a point of frustration with the board and management team that didn't just happen overnight. And for the board to respond, or a management team to respond by saying, we're going to do everything we can to attack the requisition, we're going to ignore the requisition, say that it's faulty, force them to either give us a new requisition or go to court. Then we're going to wait the 21 days and wait to day 20 or day 21 to requisition a meeting. And then we're going to set the meeting date as far out as we possibly can. That's a board that has already taken a strategic approach that I would suggest is not necessarily in the best interest of the company. Because you've got to step back and ask, when you get that requisition, not what are we legally required to do? That's an important consideration. But you have to address a different question, which is, given that there is a shareholder who has taken this step, what do we really believe is in the best interest of the company? And develop a strategy that's going to deal with that, which likely is going to mean thinking about re-engaging with this activist, and at the same time, developing a public response that is going to be consistent with showing that this is a responsible board, as opposed to making the conflict worse and getting to the point where you're spending, I gotta say, millions of dollars on a conflict.
David, oh, sorry, you had a question? Oh, Amy, yes. Hold on for just 1 sec. Let's just get the mic. Oh, you are loud, but people on the web can't hear you. Maybe they can.
So here's two questions. One, on two topics that you guys brought up. So first of all, I've heard debates amongst counsel about, is the mere fact that somebody requisitions a meeting, is that material information? So if I don't disclose, if I as the requisitioner don't put out the PR, when the company receives the requisition, should they in fact put out a PR, is that material? And second, to David's point, and I like your altruistic, nice views up there. But let's talk factually. Should the regulators just step in and say, here's, because we know that the law is a little murky around when a meeting should be called. Is it your view that there should just be regulation around it that basically states you need to call a meeting within X days unless the company has a legitimate reason or whatever they want to define as legitimate to kind of get rid of some of these, call it, tactics, game playing, etc. Would that just simplify the world?
Let me answer your second question first, if you don't, because the most modern corporate statute that's out there right now is the BC corporate statute, and that's the one statute that actually says not only gives you a time by which you must call the meeting, it also says the meeting must be held within 4 months. So that's the most recent regulatory response to this issue. It takes forever to amend a corporate statute. As some of you know, they've been working forever to try to, at the margins, make some changes to the CBCA. In an ideal world, I think that's right, because all of this stuff is tactical. And at the end of the day, like I said, we all represent both sides. Like, what we really want in the end of the day is for shareholders to be making these decisions. And everything else is noise. And for so long as that noise is available, people are going to use it. But in an ideal world, yeah, I mean, I personally would like to see that, because that would just take some of the friction out of the system. That people, when they come look at our system and go, like, some of this stuff is just silly. So in that sense, I would. But until that happens, I think there's a lot of room. With respect to your other question in terms of the requisition, my view, and it may be different than the people on this panel, is that if it's not publicly disclosed, the requisition, I think there is an argument to be made that may not necessarily have to be disclosed. The board has to make a determination as to whether this is material information that ought to be shared with the market. I've seen situations where they don't. But I think under an abundance of caution, when you're talking about something that relates to significant potential change in the governance of a company, the tendency typically, at least in my experience, is disclosure. But I've had these debates, and I've been in situations where the decision has been to not disclose the fact that a requisition has been received. Part of it, though, is when the other question from a PR perspective is, well, who wants to control the narrative? Do you want, who wants to be out there first, controlling that narrative?
Well, just play it out. So 2 parts. First of all,
Yep.
I'd say, I mean, the smell test. If you're an investor in a company or
Yep.
a potential investor in a company, the fact that someone who's representing, the directors who represent your interests on the board, the fact that the composition of the board may change, forget the legal definition, I would want to know that. that could definitely, that's something that could reasonably impact my decision on if I want to invest.
Yeah.
The other part, and this touches on what John was just saying, play it out. So somebody puts in a requisition, you don't disclose it. A week later, they announce, we put in this requisition to the company. Why isn't the company
Right.
like
That's,
how do,
that's
so
where the discussion usually ends up going to
Right.
getting to disclosure.
So now you have an external party that looks like it's doing the job of the company when it
Right.
comes to disclosure, and I would suggest in most situations that's not a good look for the company.
So David and Joel,
I just
sorry, go
gotta
ahead,
say,
David.
I have a different approach to thinking about disclosure that I would offer, just a simple framework, and it's this. I think that the fact that somebody requisitions a meeting is likely an important material fact. If somebody says the requisition notice is invalid, and they have a good reason for saying that, perhaps you could say this isn't a material fact. But my question to people in a board and a management team and advisors who are perhaps helping a board come to the conclusion they don't need to make disclosure is I'd ask, why are you not wanting to make disclosure? Because there really isn't a good reason for not making disclosure except hoping that the problem will go away. And that's not a good answer. And to me, the decision to not make disclosure is likely consistent with a board and management team that have truly lost some confidence in how they're dealing with shareholders. And so I don't like the idea of not disclosing it. I wouldn't like the discussion about not disclosing it. And I could see myself looking at a board and management team. If you don't disclose that, you wear that risk. On the second question, I just want to come to that.
Yeah.
I guess I have, Amy, you referred to it as being altruistic. I don't like
It
to
is not
think that I'm
altruistic, I can assure you
altruistic.
That won't fit.
I will tend to tell people that I tend to be more positive than many others, which may be odd for a litigation lawyer, but I really don't think that the answer should come from a regulatory scheme or an amendment to a corporate statute that says, here is the specific timeline for setting a meeting. Because if that's where one gets to, you're really saying that boards and management team can't be counted on to properly deal with these problems in setting a meeting in a reasonable time frame. And one of the real practical problems with these moments when they arise in corporate life and the board sits there and says, when do we have to set the meeting? And a lawyer turns to somebody like me or John and corporate counsel and says, when can we set the meeting? And you say, well, there's no clear answer. And if you get into how late can we push it out? And then you say, well, practically, case law suggests probably 4 months is an outside limit. Beyond that, that's getting really hard to justify. But here's the practical answer. You can set a date as late as you want, so long as you believe the shareholder that's trying to call the meeting isn't going to bring an application to court to challenge your decision on what the date is you set. Now, on the other side, if you're the shareholder trying to get a meeting date set, and you say, my God, they've set this meeting date out so far, can we challenge it? Then you're left with the reality of saying to that shareholder, sure, we can commence an application, draft an affidavit, go to court, say the board has set a meeting that's at 6 months and it should be 3 months, 4 months it should be 3 months. And now what you've done is you've actually added both cost and increased again the time to get to your meeting, because you've now introduced a legal conflict and you're asking a judge to deal with that. And so, and again, I would look at that and I would say in that scenario, in all likelihood, the tough choice for the shareholder is to say, I just want a date set. And then to use that as a piece of criticism of the board for saying, look how far off they've put this. And use that as a basis for criticizing the board. If I'm on the board side, I would actually want to change the dialogue and ask a different question. what would happen if you had a meeting quickly? What would happen if instead of taking the response of putting this out as far as you can, you said, you know what, we're confident in our strategy, we know our shareholder base, we think that if we have this in 2 months or 6 weeks, that activist isn't going to get the traction that they need. Because it can be. But I'm just saying, these are discussions I don't know that people have all the time. Because I think a lot of advisors come in and the response is, I want to defend the board, I want to defend the management team, and we should put this off as long as possible, come up with every strategic choice we can make to tactically frustrate the shareholder and cause them to say, maybe we don't want this fight. As opposed to recognizing an institutional investor that's got to this point has already made an investment in the fight and is looking for, at the end of the day, an answer to achieving returns.
I would
it's
say
not
one
just
thing,
about changing the board.
I would just say one thing to that, and it's interesting because at the end of the day, these financial institutions are economic actors. And in some cases, if a board tactically is throwing obstacles in the way of that investor, forcing the investor to make a decision, are we going to incur additional legal costs? Are we going to do this? They may be thinking, we may be able to thwart this activist because we're going to throw everything at them. And, you know, for example, in the TSXV world, I think that is, you know, the return, the legal spend impacts the returns. In larger companies, it's less of an issue because it's, I mean, it's always an issue, but it's less of an issue because it has a, I guess, it has an impact on returns, but a lesser impact on returns. And so I think that depending in where the fight is happening, these tactics will have varying degrees of success and utility to a board that's looking to frustrate the activist. If the board, to David's point, in exercising its fiduciary duty, believes that it's in the best interest of the company to push this investor away. And that is a reasonable conclusion to arrive at as a board if you fundamentally disagree, for instance, with the thesis that the investor is putting forward and its white paper and its view of how the company should be going. Jeff, you got a question?
So one thing I'll just say, just before
go ahead,
Jeff's waiting
Brenda.
for the microphone, is that this is kind of, it's an ongoing conversation, and you constantly have to assess that at each stage of the game. You can't just make a decision and then let it ride, and you're constantly with all of your team and all of your advisors. You have to be, routinely engaging and thinking about how this is going to evolve to make the right choices at the right time.
Yeah.
On the subject of expenses, I wonder if you could comment on your view of the company reimbursing the costs of a particular shareholder or small group of shareholders, legal and other costs upon the culmination of an activist campaign. And what are the reasons that a board should or should not reimburse those costs?
Yep. David, do you want to take this one?
Well, first of all, there's a statutory obligation to reimburse the shareholder for the costs of requisitioning a meeting. And so there is some obligation to provide compensation for that. The debate can really focus on what are those costs and what are the reasonable costs that properly should be reimbursed. So I guess I would start with thinking about the fact you have an obligation, assuming a requisition of a meeting, to respond and offer to pay those costs. But then the real dynamic is, do you have to pay them all? And how reasonable is the ask? And again, if it's an unreasonable ask, are both parties prepared to have a legal fight around what is the right amount of money that they should pay? We don't have many cases because the cost of that form of litigation around expenses doesn't make sense for the amount that's going to be recovered, and they tend to be resolved.
I would just say you have to make a distinction, at least from a legal perspective, of shareholders' rights who requisition a meeting versus shareholders who have no right if it's just an AGM. There's actually a legal right in the statute if you requisition. There is no legal right. So often it's just a question of settlement or negotiation on that. But
it's a great point in terms of thinking about it, again, from a board perspective. If you're facing the requisition of a meeting and you're engaged in that strategic issue of trying to deal with a conflict and you're going down a path with financial advisors leading toward a meeting, there's the company expense, that you're incurring every month, which is going to be escalating, and you're not paying attention to the expense that the activist is incurring, which could become your obligation to pay. And in thinking about the company's best interest, you can't just think about your side. You've got to be mindful of the fact that you may have an obligation to deal with their costs. And that gets to be more difficult as you get further into the process and both sides get tired of the cost, the acrimony, the personal attacks that end up taking place, and shareholders who are not directly involved in the fight, institutional shareholders can weigh in and say, we want to see a fix. We don't want to see a vote. And now, in that environment, you start to have a discussion around settlement. But in that settlement discussion, the activist is always going to say, there was an opportunity to deal with this earlier. I need to get paid. And it's an awkward bargaining point. And I think that you're going to end up paying. But for a board, I think one of the unfortunate things is both sides at the end of these campaigns end up with costs that are, I think if you looked at them at the outset and one said you're going to spend $3 to $5 to $7 million or $8 million, they'd say that's extraordinary and doesn't make sense.
I'm just going to, just for the interest of being mindful of time, I'm just going to move on to our next point in the story. So a few of the directors are absolutely incensed by some of the personal attacks that we always see in the activist press release and want the company to not only publicly rebut these attacks, but also to respond by pointing out that the principal of the activist investor has a history of substance abuse problems and multiple impaired driving offenses. Joel, is this a good idea? And when, if ever, should the company or either party be engaging in personal attacks? And how important is it to rebut personal attacks made by the activists?
So, no, it's not a good idea. Let me get that. let me get that out of the way. Unless he's running to be the bus driver or something like that. You know, alcoholism, is not something you should be getting into. But I get back to the core thesis that activists are investors. It's really about value. It may become about personality. It may get salacious. But to the extent that one side appears to be saying things that are not grounded in serious governance and what's in the best interest of all shareholders, I think the company actually has an opportunity to draw a contrast between the protagonist who is flailing about and calling people names versus, it's an opportunity to show that the company is calm, in control, focused directly on value. You can deal with it, the attack, the personal attack, in a calm and measured way, but you're not going to go back and forth. I would recommend to the client that you really have to stay focused on your core narrative, why shareholders should be supporting your side. Let the other side flail about if they're going to, and I think in the long run, in a proxy contest, there's some shareholders, it's sort of like, unfortunately, it's a bad analogy, but a car crash where everybody rubbernecks. Everyone wants to see. They're not sure what they're going to see, but they slow down and take a look. It's salacious. But there may be a small group on public forums or in the newspaper who are taking public personal shots. There's also typically a silent majority who is looking for an adult. Who is going to be the grown-up here? Who is going to be the best steward of my investment? And that's the side I would counsel my client to be on.
So David, in these mudslinging moments, is there a risk of liability for libel or slander if someone goes too far in what they say?
There always is. You can end up making defamatory and slanderous statements and create a different kind of legal exposure, I would say, unnecessarily. To Joel's point, I don't think that attacking people's personal characteristics help anything. But the reality is, when one moves toward a vote, you can't help but avoid the fact it's personal, because you've got a board that's putting forward a slate of directors their names, their pictures, their biographies, and there's a rationale of why these people should be elected and should stay as directors. And our protagonist has put up a competing slate of individuals, their pictures, their biographies, and their rationale of why these people would be better. We can't think that that's, sorry, not personal. And it's very difficult for people to avoid reacting emotionally. And yet I think the best counsel is to keep the debate focused in a different way. But there will be a tendency to want to look at saying why that person who's proposed couldn't possibly be a good director.
Yeah.
What's the standard for libel though? Like what would you have to do to get yourself into that kind of trouble?
Make a false statement that impinges or affects somebody's character and integrity. So accusing somebody of being a drunk or having committed a criminal offense when they have not would certainly expose you to a defamation lawsuit.
Right. Now, just to pick
Simply
up,
challenging somebody's judgment, I don't think goes there.
statements of fact that have a bearing, that should have a bearing on somebody's ability to vote and make a rational choice. Is this person potentially going to represent my interests well on the board? That's all fair game. Their track record as a director at other companies, how the company's performed, but it has to have some relevance. That, for me, that's the line. It has to have some reasonable. Would a reasonable person want this information? Name calling. No.
So Joel's talking like high and mighty, but as I said at the beginning, he'll say all this crazy stuff at the beginning. Typically what happens. But just so everybody knows, when it comes out, we've beaten him down quite a bit. Is that fair?
We'll talk after.
Okay, fine. So I have a question for Brenda, but first let me just add some more facts here. So let's assume that the activist delivered a valid requisition with its nominees identified, and the company responded by setting a meeting date that's 4 months away. Once the meeting date is set, the activist ramps up its public relations campaign by publishing a white paper, providing further analysis of the shortcomings of the board and why its proposed asset sale will generate better value for shareholders than the company's current plan. The company also starts hearing that the activist is actively soliciting some of the company's largest shareholders, even though it hasn't yet filed a proxy circular. So Brenda, is there anything wrong with this, with any of this? Are there any restrictions on the activist's ability to talk to other shareholders or to get commitments from them to vote in favor of the activist nominees?
So the general legal rule is on the part of issuers and dissidents is that you can't solicit without filing a circular. There are two exemptions that are applicable. One primary exemption that's applicable for activists and dissidents to be able to go out and talk to shareholders. What we refer to as the quiet solicitation exemption, which allows an investor or a shareholder to go out and talk to up to 15 other shareholders. There's no regulation or rules about how the time frame that they need to do that in, the manner in which they need to do it in. It's just at their discretion to go and talk to these 15 people. So depending on the numbers in your example, this may be permitted without a circular. Often, and that's a good tool for people to use sort of often before it's even public, where they want to suss out what other larger shareholders' thinking is. Is it consistent with theirs? Will they be able to get them on side? Are they running up against, very loyal, management-friendly situation? And often it's used by people in advance to make sure that they know what they're getting into, whether it's worth sort of pursuing a larger fight. Another tool that's, as you evolve from that, and I know that you've used it recently, is the ability to just file what we call a skinny circular. And rather than including all of the arguments in the background and everything that you would want to include as a dissident, you can file just the legal requirements of the circular, putting forth your slate. And at that point, you're fair game to go and talk to whoever you want to talk to from a solicitation perspective.
I just pause there for 1 second. So what you're saying is that if the example I think that would be typical is if let's say there's 30 significant shareholders in a company that have the vast majority of the stock, and you want to talk to them before you go out there. The quiet solicitation right is up to 15. but you want to be making 30 phone calls. So I guess the idea would be, and this is a big cost, because what you're basically doing is you're filing and mailing to shareholders a piece of paper that they're probably not going to read, but that at least gives you the runway to go talk to whoever you want to go talk to. So it's something that's done, but it's something that is not inexpensive, and it's something that has to really be done when it makes sense, where you sort of have a significant concentrated shareholder base, but you're not quite ready to go out to the whole shareholder universe.
Right. And there's certainly nothing wrong with a shareholder from expressing their views publicly, from filing a white paper about their position. Under the public broadcast exemption, they can say whatever they want. They can make speeches about what they feel, what their intentions are. There's certainly nothing that prohibits them under the law from doing that either. And if responding to phone calls within the realms of those speeches and whatnot.
David, I have 2 questions for you. So if the company, sorry, is there a question over there? Oh yeah, Joe.
So it's a good point on the 15 shareholders, but at what point or what threshold do you think is where you officially are joint actors, or at what point do you think you're working in concert? Like say, like you said, there's no real threshold on it's 15. It doesn't matter how much they own, right? But if you talk to two shareholders who own 9.9% each, at what point are they then joint actors? Like they could agree with the activist thesis. At what point do they cross that line?
The joint actor consideration goes to insider trading and early warning reports and other factors. The solicitation, the 15 shareholders, if it's one shareholder of holdings, if there's you hold it through multiple funds, but it's all controlled by one, it'll be treated as one. You can talk to 15 of those different people. You're not going to be joint. You don't reach the joint actor until you're already having these conversations. So once you talk to one of those people, that's 1 out of 15. So once you hit 15, you can't talk to 16 unless you filed a circular.
I would just also add that I think when you cross that line into being a joint actor, you really have to be working together towards achieving a common plan in a collective manner. So it is you're asking a very good question, Joe, because it's a very gray area. And one of the examples is people always say, so let's say a bunch of shareholders write a letter to let's say low risk. K2 writes a letter saying we are very unhappy with the company. We've spoken to other shareholders. They support us. Then there's another letter. K2 writes a letter and it copies Starboard. Then you're sort of, I don't know, are they joint actors? Are they not joint actors? The obvious then, sure, joint actor. If it's a joint letter from K2 and Starboard, then you're joint actors. So it's a very murky situation, and this is the answer that everybody hates, but it does depend on the facts. And
right, but I'll make it easier.
Just agreeing to vote. Sorry, David. Yeah. Just agreeing to vote and being locked up is not in and of itself make you a joint actor.
But if you have internal emails between 2 groups, let's do the following. We should meet next week and develop a plan. Mm-hmm. Who's going to write the letter? Here's a draft. What are your thoughts? We'll send this letter ourselves. Next letter to come from you. And I've got those kinds of emails or records of meetings and discussions. I'd say you're getting closer to being joint actors. If you're just meeting and saying, that's funny, I think their strategic choices are inappropriate, they should move forward in this direction, that's a similar view we have. You deal with it, you've told us what you're going to do, we'll consider what we're going to do. Then comes a separate letter. I don't see that as being the same kind of fact pattern at all. Those are 2 shareholders that similarly have concerns with the board and management team, and they're expressing their own separate views. But you can imagine how you walk from being separate to being similarly acting together and trying to have a unified force together, and that probably is more suspect to being characterized as being joint actors.
Well, secondly, on the second part of that, so effectively it's more of a disclosure issue, right? So if you are technically a joint actor, like the Genesis land development, kind of a gray area, but all it really does, like, what is the penalty if you are a joint actor and don't disclose? Is it just a time delay?
Well,
Surely
also
no judge is going to say you can't vote your shares.
Well, you're
it would also
getting
depend
layered.
on the total aggregate holdings, right? If you're tripping a 20% threshold, then you're into the takeover bid rules too, right? So which is a whole other universe.
But I would add, then you're getting into my, reputationally, well, the shareholder says they're benign and that they're acting in the best interest of everyone. They purport, yet apparently they haven't disclosed that they're actually working with a small group of shareholders. Perhaps they're not actually aligned with everyone's interests, and why didn't they disclose this, and and you get down into a credibility narrative.
Based on the current case law, I would say at minimum, you're talking about potential delay and cleansing disclosure. I'm not sure that they would necessarily prohibit the voting, because I think taking away shareholder franchise, I think, is a pretty big step that a court is generally unwilling to do. But I would say there is the potential for delay if that disclosure is not forthcoming. Did you have another question, Jeff? Yeah.
Quickly, just combining a couple of the last two topics. If we're in a scenario where shareholders are talking to David's comment in a scenario fact set that you do not believe constitute acting joint actor, we agree with it, strategic plan, et cetera, but you're not working together, and then is the request an agreement to have cost reimbursement, a bright line test that would put you over the line? For example, you have that, it doesn't constitute working jointly together. We trust you, we don't want to be involved, you're going to do the right thing, it's expensive, go do what you got to do, and at the end of the day, three of us here will help bear your costs, but we're not going to be involved in the strategy documents, et cetera. We don't even want to know what you're doing day to day. Is that a bright line test, or can you still not be jointly?
I'm not going to say there is anything that ends up being a bright line test, but if three people got together and two of them said, we're not going to be taking the public risk of this, but we will finance the costs, that's a pretty important fact for saying they're joint actors. And I would say that that's something they should keep in mind. I mean, you're effectively then operating together, and you're agreeing to pay for the costs of having somebody move forward with a plan.
And the case law talks about there being a common plan, and it doesn't talk about how that common plan is affected. If you're bringing money to the table, but not necessarily being the public voice, I think there's a risk that you'd be considered to be joint actors. I would say that, yeah, I wouldn't say it's a safe harbor necessarily. So just a question for you, David. So in the white paper, what would you do if there's misrepresentations about the company? What would your response be in that situation? How would you deal with it?
Well, first, you've got to ask the question, if there are misrepresentations about the company, are those material misrepresentations? There can always be statements that are judgments that people have different views of things, but actually making a false statement about the business may not itself be really significant unless it really has an impact on share price and it's a material fact. If I'm confronted with somebody that's making material misstatements, I think the company has these things to think about. One, responding publicly with a corrective statement in terms of specifically addressing what the misstatement is. Secondly, I think I would look at contacting the OSC and bringing to their attention the fact that you've got a concern with how this contest is evolving from a disclosure perspective, and try to engage the OSC. And I don't think it's difficult to get them to be engaged in dealing with disclosure issues. They may not want to get involved in as much in what they might view as a shareholder dispute, but trying to manage that, having them involved isn't a bad thing. The third thing you'd consider, depending upon the extent of the misstatement, is this a statement for which it's appropriate to bring an action against the person for making a misstatement that's directed toward causing harm to the company? And that's a different kind of legal issue to get into, and it's not one that really arises that often in terms of somebody making that kind of a misstatement. We've seen those kinds of actions around the behavior of short sellers and research firms like Muddy Waters and Sinoforest, and other cases where a board or management team has said they're so far offside, they're trying to make statements to advance their own financial interests and hurt the company. But that's a rare fact pattern.
Yeah, fair enough. And just one more question on this topic for Brenda, maybe Joel as well. So let's say, the activist has this advantage. They can start soliciting. They have their PR campaign, and it's gaining traction. The company wants to fight back, but they haven't yet filed a proxy circular. Can the company start reaching out to shareholders, and can it sort of launch its own PR campaign before the circular's out?
Yeah, I
answer,
mean, you can
and then PR.
show to the legal side. Legally, again, the issuer can't solicit, and that is a broad legal term, without filing a circular. But the jurisprudence has held that issuers are in a position to respond to things being said about them or about the company. So practically speaking, we've seen a very broad approach and interpretation to the use of that, and issuers being able to speak quite broadly about a number of things without actually having to file the circular or in advance of filing that circular. Maybe you could speak to sort of the nature of that response.
The comms perspective is you cannot solicit, but what is solicit? What's that line? For me, and we have a bunch of lawyers in the room, so you can all correct me if I'm wrong, a company can always talk about its strategy. A company can always talk about its directors and their qualifications. If Brenda is the shareholder and Jim is a dissident director, I think if I went to Brenda and said, will you vote for me? I need you to vote for me. That would clearly be solicitation. If I went to Brenda and said, Jim is bad, here's why, that's, I would think, close to solicitation, not solicitation. If I said, here's why our company is great, here's why our strategy is great, here's why I believe we're on the right path, how do you think things are going? I don't think that's solicitation. I think that's what a company should be doing at all times, and especially in this situation. So,
and I think the OSC at least has been extremely unhelpful in providing guidance in these cases. I don't know if anyone from the OSC is here, but I apologize. But
there's some people.
You have not been helpful if you're on the web. I have to tell you that.
There's a table to the right.
There you are. Yeah,
just to be clear, he's saying that.
Yeah.
I think you're great.
We can have this conversation, but other than in other situations, you're extremely helpful. So I just put it out there.
Walk it back, John. Walk it back.
I can't. It's already out there. So just in the interest of time, I'm just going to advance a few of the facts and get to some stuff on ISS and Glass Lewis, because I think that's of interest. So. I'll just tell you where we are in our little fact pattern. The company's mailed its proxy circular, which, thanks to our friend Joel here, successfully and succinctly rebuts most of the activist arguments. Okay, hold on a second. And lays out the vision, and then the dissident puts out their proxy circulars. So we're now into full out proxy contest, and there's some back and forth on who is going to be, who the slates will be. So ISS and Glass Lewis recommendations come out. One of them recommends in favor of re-electing the entire incumbent slate, and the other recommends electing 3 of the dissident nominees. The board also believes that it has solid support from 35% of the outstanding shares and is reasonably confident about another 20%. The activist reaches out and suggests that the two sides meet to discuss a potential settlement. So I guess I would say to Joel, should the company consider settling at this point? And how confident should the company be that shareholders who are saying that they will vote in favor of the board and that say they will follow Glass Lewis and ISS, like how useful is this information at this stage of the process?
So it's a lot of information that you have to weigh through. I'll deal with it in parts. First of all, ISS and Glass Lewis, for those who aren't familiar, those are the 2 most important proxy advisors. Historically, institutional investors subscribe to many subscribe to one or both, and their voting recommendation heavily influences how the shareholder votes, that institution votes. In practice, recently, I would say, you're finding results when proxy contests go the whole way and there's a voting result. More often than not, I think, they don't reflect necessarily, well, ISS and Glass Lewis rarely make the same recommendation. But then if you look at the final result, it doesn't necessarily reflect what ISS and Glass Lewis recommended. So,
Yeah, I mean, I would say that these institutions take pride in the fact that they make their own decisions.
but that's new.
That is new.
That's
That is new.
evolving. It used to be, you look at the shareholder list, you look at ISS subscribers, Glass Lewis subscribers, and yeah, it could change. We have a pretty good idea what's going to happen. So, now you in your case, you've told me you have 35%. You're feeling pretty good. Oh, there's a chart. There we go. 35%, 20% likely. So that's over 50% of the total issued and outstanding shares of the company, giving vote turnout somewhere maybe in the 80s, the 90s. So you're looking at this. You're feeling really good if you're looking at this right now from a company perspective. However, I would caution you in that we give the Canadian no, which you go in a meeting and you meet with the shareholder, and the shareholder goes, "You've given me a lot to think about. Thank you for your time." And you walk away going, "Wow,
Got them in the bag.
we got them."
Yeah.
Right? Not necessarily true. So you have to be really honest with yourself and within the group. How are they really with us? And I think this is a good way to do it. The sort of solid and likely columns, and then you know what the against are. So you're feeling good at this point. Should you enter into negotiations? Look, I think if the other side wants to talk to you, I think other than rare instances where maybe you've tried it 7 or 10 times and it's gone nowhere and you're at the very end, I think it's in the board's interest and the right thing for them always to engage to see if there is a better outcome. We've talked about the cost, right? We've talked about the reputational damage. So there's a number of factors here beyond simply the win at the ballot box. So I think in good faith, you can negotiate, or if nothing else, go and listen, because you don't know what you're going to be told.
David, what are the key terms of a settlement agreement? And to Jeff's earlier question, would that ever involve costs?
I think it would always involve costs, but I don't think that's the first thing people focus on in the discussion. Cost ends up being an afterthought. The starting point is going to be, are there changes in the board, like particular people that will be removed and replaced? And then I think from the company's perspective, you're going to want a standstill agreement for as long as you can get, so that you have the faith of knowing that this particular activist is supporting the board and the management team, and you're not going to go through this again in short order. So those would probably be the most significant issues. And then the next step is going to be a discussion around the costs. And it's not something that should, I think probably people realize it's not something that should interfere with a constructive agreement, and that probably is what leads to people or companies paying more of the costs than they otherwise might, because they're trying to reach an agreement. I just want to go back to Joel's point about ISS. I want to think about this differently, just to leave you with a different thought on it. If you get to the point that ISS or Glass Lewis in this process are meeting with the shareholder that's leading a campaign, and they're meeting with other shareholders, and then they're interviewing the company, and one of them writes a report saying that they think that 3 of the dissident directors should be appointed, that really, from my perspective for the company, there's no good answer to that. And I think the company has to look at either reaching an agreement on its own, or I think if I was on the board and I saw that an institutional, sophisticated group like ISS or Glass Lewis was saying, I should be replaced, I don't know how good I'd feel about saying, I'm going to stay on this board and force this to a vote. And so I think it's actually an interesting problem, and it can be dealt with in I'm going to offer 2 ways. One is you negotiate a settlement. If you can't reach an agreement on a settlement, then a really aggressive and interesting approach for a board to take is to be magnanimous and to say, you know what, as we move forward to this election, recognizing what shareholders have told us, we're going to change 2 or 3 members of the board. And to actually do that, either taking from the dissident slate, as has been recommended, or identifying others. And that would change the dynamic. But I think a board in the face of that has to accept the fact it's got a performance problem, which is what's led them to get to this point. It's got a failure to communicate with shareholders that's got them to this point. And they've got somebody specifically saying 3 of you should be replaced. They need to act differently than they are. I think putting your head in the sand and having saying, I'm going to go forward with a fight and think we can win, is a short-sighted board that, again, isn't thinking about the best interests of the company.
mindful of time, we have 5 minutes left. I'm just going to ask, so let's say the settlement talks go nowhere, and just a quick question for you, Brenda, just if you can quickly comment on the fact of the use of paying solicitation fees for every vote their clients cast. This is the practice of vote buying.
Right.
What's the current state of play on that right now?
Technically, you can do it. There's a big push and a movement towards curbing that practice. I think it's highly scrutinized. I don't think anybody would entertain that in the current environment. That's kind of I'm looking at the time here, so I'm like, that's the short answer. That it is technically still possible, but I don't think that we're going to see a lot of that in the current climate.
We do have some other topics, but I think as a result of this good discussion, we didn't get to cover everything. But I mean, it gives you a sense of sort of how these issues come up as a proxy fight does play out. While we just have a few minutes left, if anybody has any other questions, I'm happy to answer them. But if not, I think we're done. So I'd like to thank the panelists. I'd like to thank you all for coming. And if you do have any questions on stuff we didn't cover, which sort of deals with meeting protocols, reviewing proxy results, all that type of stuff, happy to answer any of those questions once this is over, or happy to discuss anything else further. So thank you very much for your time. We appreciate it. Thank you.
Thanks, everyone.